Us. In fact, we are also joined by a guest on the show. We have Aditya Pratap, who is a lawyer, joining us on the broadcast as well. Good afternoon. Thank you very much, Mr. Aditya Pratap, for speaking with us here on Times Now. Your first reaction to this observation by the Allahabad High Court, and activists clearly are quite angry with the kind of details that have emerged, the observations that have been made, that grabbing breasts is not an attempt to rape. This can attract minor charges, but it can't be considered an attempt to rape. This only amounts to preparation. Like, seriously?
Well, see, of course, now this is a classic conundrum, I would say. If you look at the definition of rape, rape is defined in section 63 of the Bharatiya Nyaya Sanhita as any person. If you see section 63, 63A says a man is said to commit rape if he penetrates his penis to any, we have A, we have B, and third, manipulates any part of the body of a woman. So in my opinion, the court in this case should have looked at the mens rea. What was the intent? See, when he's loosening pajama strings, he's taking all the steps to prepare to commit the assault. So in my opinion,
in that case, like you also agreed here, the acts, that you just now mentioned, it is an act of preparation to commit an offense, to commit a crime.
Yes.
So why should it not then attract strict punishment? Why shouldn't there be strict charges against it? Are we waiting for something to happen and then we will call it a rape case?
See, if we looking at the details of the case which are prima facie available in the public domain, what I can say is that, here every judge has a bit of a dilemma because criminal law has to be interpreted and construed strictly. So you cannot, because unlike a welfare legislation, criminal law, a welfare legislation, you can give it a wide interpretation. But criminal law, because it pertains to punishing a person, putting a person behind bars, you have to interpret it strictly. So probably the court had a bit of a conundrum because, the definition of rape is very strictly defined. The, insertion, penetration, manipulation so as to cause penetration. So probably the court was of the opinion that the committing of the crime had not reached that stage where it would amount to something like actually, attempting to penetrate. So it's a very thin line here. It might also, cause anguish among the general public. But see, while on one hand, I can definitely say that when you look at the mens rea, because Indian criminal law does look at mens rea, but
Mr. Aditya Pratap, again, you are acknowledging that there is a thin line here. Should we not do something about it? Is it not serious enough? That's what I want to ask you. Should it continue? I completely understand that as far as law is concerned, rape, there is a specific definition that it follows. Only in certain acts it can qualify as rape. I understand all of that. But you yourself are agreeing to the fact here that there is a thin line here. Are we waiting for a crime to be committed and then only such sections should be slapped? Or do you think perhaps there is a need to change it? Because this is unprecedented, and like you yourself mentioned, this has caused a lot of outrage as well among people across India, not just activists.
See, as far as grabbing of breasts is concerned, okay, the lawyer for the accused might still try to associate it with some other offense, like molestation or the other things. But here in this case, this is a clear crime against women because the court has to think that why would a person loosen pajama strings? Why would a person loosen pajama strings? So in such a case, question is, can the court draw a presumption? Because somehow, if I'm not mistaken, there is no provision for presumption. Because you have to see that way whether the law puts in a requirement for presumption or not. For example, okay, if you're attempting to open pajama strings, then a threshold for presumption might come in. Now the court will presume that you want to commit rape and then you prove otherwise. But in India, as you know, innocent until proven guilty, and the prosecution has to prove each and every charge in a criminal case. So here, this is where, because obviously the lawyer for the accused is going to deny that his client committed a crime. But then the prosecution can argue, why did you loosen? Because what they have to show is that by loosening the pajama strings, the intention to commit rape is there. So which would qualify as attempt. So I do feel that it's likely that obviously this matter is likely to go up to the Supreme Court, but we can expect some very, hard-boiled judicial decision-making on this point.
Okay.
Where a lot of precedents and case laws will be.
Okay, continues to be with us as well, Aditya Pratap. Aditya, you heard a valid point raised by one of our viewers, and that's what a lot of activists are also talking about. Just imagine the repercussions of this kind of an observation. Tomorrow, people will think it's okay to touch somebody's breast. It's okay to loosen somebody's pajama string, because this will not amount to attempt to rape.
See, well, as I said now, I have gone through more details of the incident also. There was grabbing of breasts, there was loosening of pajama strings, and then there was, dragging under the culvert. Obviously, with the view to dragging the victim to a secluded place with the intent to commit the act. So what I feel is, let us go step by step. Grabbing the breasts, 354, molestation, because this is governed by IPC. From what I understand, this criminal offense has been going on under the IPC. Then court imposed 354B, assault or use of criminal force to women with intent to disrobe. Any man who assaults or uses criminal force with the intention of disrobing, compelling her to be naked. Now, this will also fall under 354B. But the third part, dragging under the culvert, because you know very well that accused criminals, they want to commit this act away from public eye. So I feel the third part, which was that is certainly can become a ground of appeal. The Supreme Court can be approached, because in my opinion, attempting to drag under the culvert, see people grabbing breasts, fiddling with private parts, that do it in public domain. But dragging under the culvert, I think that can be an ingredient for attempt to rape.
All right. Thank you very much, Aditya Pratap. Appreciate you joining us here on Times Now and sharing with us your perspective. Of course, this is going to be a